Good morning, everyone. The organizing committee welcome you to the second day of the second Brazil-Japan Litigation and Society Seminar. For those of you who weren't here yesterday, I'm Daniel Machado, a PhD student from Tokyo University. First, I would like to make an announcement. Yesterday, we had a lot from ESA, and you received this sorry, this paper in the beginning, and there are 5 winners. I don't know if everyone is here today, but they're Adriana Zaitz, José Carlos Lopes da Silva Júnior, Rodrigo Chagas, Cíntia Santos Ruiz Braga, Cristina Ramos. And also, if anyone found a laser pointer yesterday, please deliver it to the organizing committee. So the first, today we will start with session 6, ADR in labor law, family law, and environmental law. The session goes from 9 to 10. Professor Daniela Cabai from Getúlio Vargas Foundation will preside the session. Professor, the floor is yours.
Thank you very much for the introduction. It's a great honor to be here in this event, this great event, and in this panel, especially about ADR in labor law, family law, and environment law. I'd like to congratulate the organization committee in the name of Professor Antonio Rodrigues and Célia Zaparoli, and give straight the word to Dr. Koji Kameda. So give your speech.
Good morning, everyone. Good morning. I'm Koji Kameda. I'm not an academic researcher. I'm a practicing lawyer specialized in labor law disputes. I mainly give advice to the companies. And in this session, I will talk about ADR in labor law in Japan. I will focus on the labor tribunal system, which was introduced in 2006 to resolve the individual labor disputes. Yesterday, Professor Araki briefly explained the labor tribunal system, and as he said, generally speaking, the labor tribunal system was a great success in the Japanese labor law dispute resolution system. So today I will roughly illustrate how it works and explain the possible reasons for its success. First, let me explain the situation before the introduction of the labor tribunal system. This is a chart of ordinary lawsuit cases of labor disputes newly filed with the court of the first instance before 2006. As you can see, the number of cases was increasing and increasing before 2006 and tripled in 20 years. And one of the reasons for this increase is so-called the collapse of the bubble economy. Japan experienced a sharp economic decline at the beginning of the 1990s and suffered from a long-lasting economic depression. Because of it, companies conducted job cuts, salary reductions, business restructuring, and so on. So the increase was seen in individual labor disputes. In other words, disputes between employers and employees, rather than between employers and labor unions. Next, let me briefly explain legal options employees have to resolve their individual labor disputes. Firstly, they can hire a lawyer and send a lawyer's letter to the company and have out-of-court negotiations. If the dispute is just about money, then the dispute can be settled very quickly. However, such kind of negotiation doesn't always happen. And even if the negotiation happens, there is no guarantee to reach settlement. If the negotiation breaks down, then the employee has to resort to another legal proceedings. Secondly, the employee can use administrative mediation, which was introduced in 2001 to resolve the increasing number of individual labor disputes. Mediator appointed from lawyers or scholars is involved with the settlement negotiation, and with the assistance of the mediator, they can settle the case more effectively. The biggest problem for the employee side is that employer doesn't have to participate in the proceeding. Employers can just say they will not attend the hearing. In that case, the procedure is over without holding any hearing. Then the employee has to resort to another legal proceeding. The participation rate was about 67% in 2018. And again, in the same way as the negotiation between lawyers, there is no guarantee to reach settlement. Having said that, once the hearing is held, the settlement rate is quite high. In 2018, about 65% of the cases are settled in the mediation procedures. Thirdly, they can file a lawsuit. Then detailed examination is conducted by professional judges, and the award can be bigger than the out-of-court negotiations or administrative mediation. However, the legal procedure are very, very lengthy. In 2018, the average length of procedures until the judgment of the first instance was 14.5 months until the judgment of the first instance. And the labor tribunal system is a kind of in the medium between the administrative mediation and the lawsuit. It was introduced in 2006, and this system is available for individual labor disputes. In other words, disputes between an employer and the employee. It can't be used for disputes between a labor union and an employee, labor union and employer, or disputes between an employee and another employee. And the court is involved, but the hearings are less formal than ordinary lawsuits with a view to settling disputes rapidly. As Professor Araki explained, Labor Tribunal Committee consists of one professional judge and two expert part members. Two expert part members were appointed from companies' officers and labor union officers. Generally speaking, the labor tribunal system has been regarded as a great success. Firstly, the system has been dealing with cases very rapidly as initially contemplated. I will explain the procedures later, but basically, only 3 hearings are held, and the first hearing is most important. The parties have to submit all assertions and evidence before the first hearing, and based on the result of the first hearing, the Labor Tribunal Committee quickly starts settlement discussion at the first hearing. Basically, the second and third hearings are held only for the settlement discussion. On average, it takes only 2.6 months from petition to conclusion of the case in 2017. Secondly, the settlement rate of the labor-driven system is quite high. About 70% of the cases are resolved by settlement. And thirdly, the employee side has given positive feedback regarding their experience. About 60% of employees are satisfied with their experience. On the other hand, satisfaction rate of employers is only 35%, but it is no surprise because employers are forced to participate in the proceedings following a petition by employees. And in most cases, employers have to pay some settlement money to resolve the disputes. So the important thing is that the employees' satisfaction rate is very high. Sorry. This chart shows how the procedures proceed. An employee files a written petition with the court, and the first hearing is designated about 40 days from the petition. 1 week before the first hearing, the employer has to submit a written response with all the evidence. The settlement discussion starts at the first hearing, and about 35% of the cases are concluded in the first hearing. And 37% of the cases are concluded in the second hearing, and 21% of cases are concluded in the third hearing. As I said, parties have to submit all the assertions and evidence before the first hearing, and basically there is no chance to add assertions or evidence later. At the hearings, Labor Tribunal Committee and the petitioner and respondent sit around the round table, and at the first hearing, the committee sorts out the issues and the evidence and asks questions directly to the petitioner and respondent instead of asking to lawyers. This is like a direct witness examination of the ordinary lawsuit. So the petitioner or the respondent have to answer the question by the committee by themselves. Then the committee has an internal discussion about which side should win or how the possible settlement should be. Then the committee has discussion with each party individually about the settlement, and based on such discussions, the committee gives a settlement proposal at the first hearing. And parties negotiate on the proposal settlement, and if they reach agreement, the proceedings are concluded by settlement, which means the dispute is resolved. It's the top of this chart. If they could not reach agreement, in most cases, the committee issues a decision to the case, and the proceedings are concluded by such a decision. Then, if a party who is not happy with the decision must file a written objection within 2 weeks. If no objection is filed, the decision becomes final and binding, which means the dispute is resolved. And if an objection is filed by either party, the decision becomes null and void, and the case is automatically transferred to ordinary lawsuit. So the green scenario is the settlement is resolved, but if the decision is objected, then it will automatically be transferred to ordinary lawsuit. As I said, about 70% of cases are resolved by settlement. Probably factors described in this slide has contributed to the high settlement rate. Firstly, the fact that the employee chooses the labor tribunal proceedings instead of lawsuit shows the petitioner's positive attitude toward the settlement. So as long as the employer is also positive with settlement, then the settlement discussion will be very smooth. And secondly, opinion and advice given by expert members have a good influence on the parties. The committee consists of 3 members, 1 professional judge, 1 expert member appointed from the company officers, 1 expert member appointed from union officers. The expert members knows the reality of the workplace and give a realistic view. Also, as Professor Araki said yesterday, expert members give neutral opinions to the case. So persuasion of settlement by the committee is more effective than persuasion by a professional judge only. And thirdly, decision issued by the committee after the breakdown of negotiation tends to be similar to the proposed settlement. So if a party is not satisfied with the proposed settlement, then the party will not be happy with the upcoming decision as well. So the party has to raise objection to the upcoming decision. If they raise objection to the decision, then they have to pursue lawsuit, which will take huge time and costs. In addition, it can't be said that parties would get better results in the lawsuits than the proposed settlement. Before the first hearing, parties submit all assertions and evidence, and a professional judge, the committee, including a professional judge, conduct legal analysis. If the objection is filed and transferred to the ordinary lawsuit, then the professional judges will conduct legal analysis, but the professional judges tend to reach the same view as the Labor Tribunal Committee, because Labor Tribunal Committee includes 1 professional judge. So parties tend to choose to accept settlement or decision rather than pursuing lengthy and costly lawsuit. Probably these are the factors of the high settlement rate of the labor tribunal system. And what happened after the introduction of labor tribunal system in 2006? This chart shows the number of cases brought before the court. The lower layer, the blue, dense blue, is the ordinary lawsuit cases, and the upper layer is the number of labor tribunal cases. The number of labor tribunal cases increased sharply in 2009 and remains high until today. So at least it can be said that users regard the labor tribunal system as a useful option to resolve their labor disputes. On the other hand, the increase of the labor tribunal cases does not mean the decrease of lawsuit cases. Also, the ordinary lawsuit cases are increasing, so the total number of labor disputes has increased. The first point I explained, and I will explain the second point. Probably, the economic trend in Japan after the financial crisis in 2008 has affected the increase of labor disputes. Also, by introducing the labor tribunal system, employees now have a better access to the dispute resolution, which might have caused the increase of total number of cases. And the third point, employees now have more legal information because of the internet, and they are more aware of their employment rights. This is the last slide. Generally, the labor tribunal system is a success in the Japanese labor dispute resolution, but of course, there are still problems to improve. Firstly, accessibility. The labor tribunal system cannot be used at most of court branches in rural areas, so employees have to file a petition with head court offices in each prefecture. So travel time or travel cost may be access barriers for employees in rural areas. Secondly, the court's human resource. This is one of the reasons for the first point of the limited accessibility. Professional judges are tied up with long hours of hearings while they need to deal with other ordinary cases. Therefore, only court offices with sufficient number of judges can deal with the labor tribunal system. And the increasing number of labor disputes make the judges too busy, so the Tokyo District Court has established additional labor division last April. So now 4 divisions in the Tokyo District Court. And thirdly, this is not a unique issue for the labor tribunal, but the employees have to prepare attorney's fees. Legal representation is not necessary, but in reality, lawyers' involvement is very important to prepare for the first hearing. So only employees who can afford to pay legal fees might be able to use the labor tribunal system. Having said that, I think overall the labor tribunal system is going well, and I think the situation is very different between Brazil and Japan, but I hope the situation in Japan will help to consider the dispute resolution system in Brazil. Thank you. Obrigado.
Thank you, Dr. Komeda. I'll pass the word to Professor Célia Zaparoli.
Thank you. Here today, we will talk about different cultures' view in environmental multicultural mediation. Welcome, professors, colleagues, and students here in USP and YouTube channel. Welcome, professors and friends from Japan. Welcome all the people concerned with knowledge and research in Brazil. It's a challenger time for Brazil. The Brazilian resources for education and research were radically cut by the federal administration, while large debtors were forgiven in their debts. The 1988 Constitution, a citizen conquest, seems to die day by day in unrepublican actions. I'm talking about democracy and ethics, not political parties. Brazil is the earth of migration, of the multicultural. We are here, Japan and Brazil, because of that. So all migrants and refugees were and are welcome to Brazil. Even insignificant radical groups say otherwise. Brazil, we are here and built by interactions of different cultures, different looks. In some moments, built on the expense of sweat and blood and inequalities between colonizers and colonized by slavery of African and Brazilian natives. We will still have a lot of work about discrimination and inequalities issues in fields of gender, sexuality, identities, race, religion, labor. On the ground of ethics in politics and governance, legal stability, and judicial effectiveness. Perhaps in this global moment, there is an enormous difficulty to understand that we are Earth global citizens, and to understand the human diaspora. Human diaspora that comes from prehistory and in our Brazilian internal colonization, historic thing. Even with difficulties here and there, coexistence and creativity are the most important Brazilian commodities to exportation. We believe in our potential to add and welcoming to migrants and refugees. Why not to our national different culture people too? The forest, fauna, and flora needs to be protected as well. Brazilian natives need space to live. How to work with the difference. How to coexist and accommodate difference to share natives in present in the future. How to live in this shared reality. How antagonist culture positions can dialogue through mediation. That's what about I'm talking today. The mediation case. I will talk about the mediation case. Mediation case in progress between Paranapuã Brazilian Natives Community and Xixová-Japuí State Park by 3rd Region Federal Court, where we are nominated as a mediator. The facts. The origin of Brazilian natives dates back over 2,000 years. Before the discovery of Brazilian in 1,500,000. The colonization starts 1532. Originally, there were 5 to 7 million natives in Brazil. Today, they are 600 to 700,000 natives. And on Brazil coast, about 10% of them. Their culture has protected them, the few remains. 15 years ago, Paranapuã, Brazilian natives community, entered in Xixová-Japuí Park, a forest reserve, in São Vicente municipality. Today, they are 100 Brazilian natives in 3 families groups, mostly from Guarani ethnicity. Originally, they were 1.3 million kilometers of Atlantic forest in another way. Today, only 1,500 square kilometers remains. Xixová-Japuí Park was created in 1993. It's 900 hectares of preserved biomes such marine ecosystems, rock shores, rainforest, and resting forest, sand beach where the birds rest in their migration. The positions in mediation. The Paranapuã Brazilian natives claimed the land, showing us a painting that I will show for you in a few minutes. On the arrival of the Portuguese colonizer Martim Afonso de Souza to São Vicente, justifying the right of their presence in the area. According to Paranapuã Brazilian natives, much earlier than time of Mark, the Supreme Court in Raposa Serra do Mar, a precedent Brazilian natives community demarcation. So they declare they were on the land today called Xixová-Japuí since 1532. They say they had to leave the land because of the colonizers used them to work in their houses, to fight in battles, and because a practice they call Guarani visits. They stay some time in another communities living for some years. The park has a different position. It's an environmental reserve and needs to be conserved. It can be a dangerous precedent for its and other forest devastation. The Brazilian natives have been already sentenced in their first degree in federal court, I'm sorry, oops, in federal court to vacate the park. Now, notwithstanding, they were referred to mediation by a judge in a conciliation center in a civil state place to the third region federal court conciliation center. The parts in mediation. The parts in mediation are Paranapuã Brazilian Natives, Federal Public Prosecutor, State Public Prosecutor, Forest Foundation, the National Indian Foundation, the Municipality of St. Vincent. Supporting the process, we have universities, Indians' health and education sectors, and CAMI and ASP working together to third region court, federal court. I would like to highlight some points of this mediation. Our presentation and what we want to highlight today are the facts in the light of theory, trying to understand what made all the parts involved in this mediation leave their positions for a moment, turning their eyes to a common point, promoting experience of convergent and narrative and acts. This mediation was divided in two parts, the heart of the mediation and the vascularization, how I called. The heart refers to the permanence of the natives in the park or not, and how. And the vascularization refers to a fundamental rights, elected by them, health and education. While the natives are in the park during the lawsuit, a settlement or the sentence, so they have to have their fundamental rights observed. And the park and the state recognize that. We will try to explain the multicultural convergence and what happened in this particular moment. So, Boaventura de Souza Santos rereads Cicero with his grand lessons about topos. Topos can be a potent commonplaces instrument to dialogue. Topos examples are like dharma, karma, human dignity. Topos are open and incomplete narrative instruments, but the culture itself has difficulty to understand the topos as an incomplete narrative. For Santos, Boaventura de Souza Santos, its universalization can be harmful. But here, in this mediation, we are talking about different cultures in the same constitutional legal system. They are different cultures in the same constitutional system. Both Brazilians, with an interaction. And the decision to first address the mediation to fundamental rights involved fostered cohesion, unit towards a college earning. Talking of the focus of antagonist issues and return to issues to a common understanding as fundamental rights. So everybody starts to work to the same thing, the fundamental rights. Put different cultures in a broader legal system, the Brazilian constitutional law, to coexist place, generating a feeling of power for working together for a common values, fundamental rights. I remember a friend, Celso Charuri, who used to say, if you don't want a kid, put his finger or her finger in a birthday cake, invite him or her to make a cake with you. The cake will be her and his. So the cake will be protected. That's the feeling that is working in fundamental rights in this case. What happened in this case? Different what Harvard in Getting to Yes teaches. It's not about convergence, redundancy, the distance between different interests, nor the approximation for different alternatives to an agreement or settlement. We are talking about understanding each other. Brazilian citizens' universal values, therefore common, dispute diverging close positions and interests. Fundamental rights, a Brazilian universal value, a powerful way to reflect and stay and work together as the kids in the cake, birthday cake. We are talking about find a good battle, to work together as a fellow, a common cake, the kids as an example. We want to show a movie that resumes what I'm saying here. Just a minute, please. Thank you. to end my presentation, I want to thank Professor and Judge Bruno Takahashi, Judge Daldice Santana, Judge Herbert Bruin Jr., the possibility of mediating conflict between Paranapuã community and Xixová Japuí Park by the Third Region Federal Court. I want to thank fellow mediators Euclides Lourenço and Fátima Bonassa Bucher, our thesis advisor in clinical psychology, Rosane Mantilla de Souza, in PUC, São Paulo. And mainly, we want to thank Professor Antônio Rodrigues de Freitas Jr. for his morally and materially supporting in this beautiful experience. Thank you so much.
Thanks, Professor Célia. We have 15 minutes to discussion, so I will open to the audience. Please.
I would like to ask a question to Council Camila, and because I've already been to Rodoshimpam, but I would like to know the port costs. Is it expensive for a worker to go to Rodoshimpam, a labor tribunal in Japan? And I would like to ask about port costs and also about attorney's fees. Is it expensive? Because the hearings, for example, the hearing I went to, it took like one whole afternoon, like almost 4 hours. So it's a long time for one hearing.
Can I add just some question about the administrative mediation costs, if you can
Okay.
add to?
First, the procedural fee for administrative mediation is 0, so employees don't have to pay any fees. And as for the labor tribunal system, they need to pay the procedural fee. And I can't give the detailed figure, but it's the half of the cost of the procedural fee of the ordinary lawsuit. So it's cheaper than pursuing the ordinary lawsuits. But the attorney's fee, I would say that it's not cheap because for lawyers, preparing for the first hearing is very burdensome. They have to submit all the assertions and all the evidence before the first hearing. So it's very time-consuming. And so the attorney's fee tends to be bigger than the ordinary lawsuit. The fee arrangement is, in Japan, the employees have to pay the initial fee to commence the procedure. And if they win, then they can get additional legal fee from the employee. But the first initial fee is bigger than the ordinary lawsuit if they choose the labor tribunal system. Labor unions. The role for the labor tribunal system. Basically, this labor tribunal system is used for the individual labor disputes. So, generally speaking, if it is ordinary lawsuit, then the labor union can support the employees. But as for the labor tribunal system, labor unions can't attend the hearing. So basically, cases which needs the union's assistance, then they tend to choose the ordinary lawsuits rather than choosing the labor tribunal.
I have a question.
Yeah.
Do you used to do collective labor mediations?
Sorry, could you repeat that?
Collective labor mediations, do you used to do? In collective bargain.
Yes, we have another special committee to deal with the disputes between employers and labor unions.
Okay. Okay.
So labor unions can file a petition for the mediation with their special committee.
If I can add something about mediation also in the labor tribunal system. What are the main difference between the administrative mediation and this proceeding of proposed settlements you mentioned by the expert in the labor tribunal system? I mean, why not to introduce the regular mediation and not just the negotiation procedure in the labor tribunal system? I just want to hear your opinion. And to Celia, just to put the questions. Very interesting your presentation and approach about mediation and inequalities. I would like to hear about the main challenges in the mediator perspective to lead with these inequalities and the challenge of communication, if you can talk about the special training or this view by the mediator about this subject.
The biggest difference between the labor tribunal and the administrative mediation is the employer doesn't have to attend the hearing as for the administrative mediation. So if they say no, they will not attend the hearing, then the procedure is over and the dispute is not resolved. But as for the labor tribunal system, the employer is obliged to attend the hearing. If they are absent from the first hearing, then the committee will issue a very favorable decision to the case. So the employer will be attending the hearing and have a negotiation with the employee and will tend to reach settlement, very high settlement rate. Okay.
So, the communication. I am a blonde woman, Juruá. Juruá is a person, white person in Guarani language. So all the time we were talking, in the first mediation, they start to say, you don't understanding what we are saying because you are a Juruá. You are blonde, you has green eyes, so you don't understand. You had to note something. We don't have to note anything because we remember everything. So I start to go to the community, walking together. Sometimes Antonieta goes with me. So Antonieta starts to play with the kids. So then they start to understand me as a mediator. And Bruno, I don't know if you, I had a caucus days ago, Friday, and they asked me to be a mediator between them, between the natives. So I think now they are starting to understand me as a person can help them. The other side, the other perspective, the other part is Florestal Foundation. They received me easily because I was designer and mediator in Programa Serra do Mar, the first park that I show in the movie. So they know me. And if I had some problems, I start to say, do you remember Serra do Mar program? So everything is good. But I have the Indian Foundation, the native foundation that protects the Indians coming together with me. So it's easier to work with them because they can translate something. The federal prosecutors has anthropologists with them too. So sometimes I call to anthropologists, what is happening? I can't understand what is happening here or there. Can I work in this? So we are a team. Sometimes, Bruno, I need to talk with federal prosecutors. Let's go together. So we are a team. In these mediations, we are a big team. We just have to pay attention not to exclude the natives because the institutions are too heavy. And maybe we can sometimes stay talking just with us. So I try once a week or each 15 days, go to the park and do something there. And they start to understand me as a equidistant person. That's what I'm working.
Anyone else? So thank you very much. And we go to the next panel.
Thank you.
Professor Daniela, Dr. Kameda, Professor Celia, thank you very much for your presentations. Next, we'll have two simultaneous sessions, Session 7A, Criminal Litigation, and Session 7B, Law and Policy on the Retirement Process of the Elderly. Both sessions go from 10:15 to 11:15. Session A will be presided by Professor Fernanda Tatursi from FADISP, and Session B will be presided by Judge Bruno Takahashi. Session 7 will be here in this room, and Session B at room 3, the room to the left. After these sessions, Professor Masato Ninomiya will honor us with a few words to close our seminar. So please come back to this room at 11:15. Thank you. Yeah. Yes.
制度、新しく導入された合意制度の概要をブラジル法とイギリス法をちょっと比較して違いを説明してたら、で1号事件もう1号の取引事件が終わったので、それについて彼から報告いただいて、
タイの汚職ですね。
タイですね、なんかそうそう、しかもトップじゃなくて現場の人が
子会社の役員です。
脱皮されてね、そうそう今たまらんなっていう話題になってた
その話をします。
そうですか。
で法人と取引をして個人を挙げたっていうんで、日本では割と批判が起こったんですけれども、実はそれって本当に批判されることなのかというような議論もちょっと
事案として見たらあれは妥当な処理。
そうですね。少なくともその企業犯罪をグローバルで扱っている弁護士からすると、あれは非常に正しいやり方で、むしろそういうふうに日本も変えていかないといけないんだっていう話をしようかと思ってるんです。そもそも昔の体制から今に対するグローバルで見た時のコンプライアンスの体制ってちょっと違うので、その研修とか考え方自体を少しずつ変えていかないと日本の企業は大変なことになるので、シフトしていく必要があるっていう話を全体としては、
終身雇用どっぷり使っていると、
そうなんですよね。
企業内の規範が優先するだろうとそこを変えなきゃいけない。
で DOJ にこの間終身雇用の話を説明しに行ったんですけど、やっぱり全然違うんですよ。なんでクビにしないんだと。例えばこの間のよく問題になってるデータ改ざんとかあるじゃないですか。ああいうのってやっぱりもうプラクティスとしてやっちゃっていて、その職場の中ではもうその選択肢以外取れないじゃないですか。そういう中で、一応大いに、関与した人たちっていうのを、DOJ の目からすると、なんでこの人たちを会社からもう排除しちゃってきれいにしないんだっていうことを言ってくるわけです。でそれに対して僕は日本の雇用環境というのはそういうふうにはできていないので、全然違う見方をしないといけないんだっていうことをそれこそ英語で皆さん書いていただいている労働法の文献を持ってですね説明して、でこれを日本で、仮に懲戒解雇したら無効になるっていう話をして、でもうちょっとストラクチャーを変えていくっていうインプルーブメントをしないと意味がないんだっていう話をしに行ったんですけど、
そういう個人でね、そういう違法行為をするのは当然自分に見返りがあるからやってるわけだけど、日本は何の見返りもなくて、やるのは多分見返りできたいと思うんですよね。
で難しくて、直接的な見返りはないんですけど、間接的な見返りはやっぱりあるはずで、
あるんだけど、それも
非常に遠いですよね。
自分がそういう表示するよりもそうしなければ、
そうなんですよ。だからゲーム理論、ゲーム理論的には選択肢としてはないんですよね。でそういう話を今向こうとやってたりするんですよね。
ぜひ聞きたいけどね。
なんなら読んでもいくらでもしますね。
そうですから、それは面白い話。
まさに労働法とコンプライアンスが絡むところですね。
ありますね。本当にちょうどそういうなんか異文社会の方とユニバーサルの方の
そうなんですよね。
衝突で面白いですね。
それを今私はよくやってる点です。
そうですか。きっとね、皆さん勉強になって、最初に終身雇用みたいな話をちょっとしたからね、それのね、余波というかね、それをここで関係してくるんだっていう。
なんか結果的にすごくちゃんとつながったっていう
いや、つなげようと思えばつなげられるんで。
そうですか。面白いですね。犯罪って誰でもユニバーサルに起こるからね。
そうなんです
じゃあ
ね。
どういう
そうですね。
行動
そうなんですよ。行動経済学とか、そういうのも実は絡んでくるので、本当はもっと議論しないといけないところなんですけど、コンプライアンスの弁護士って結構偏ってるので、本当はもうちょっとちゃんと議論すればいろいろ議論すべきことは山ほど出てくると思うんですよね。
初日にね、カルチャーの話がね、カルチャーはどこの話だったか、まさにいわゆる文化的なカルチャーがあるんだけど、企業文化それはね、全然やっぱり違うんですよね。
アメリカではその話をちょっとしようとしていて、私はグローバルコンプライアンスプログラムの、セッションをやるんですけど、そこでコーポレートカルチャーをどう考えるかっていうのを議論したいっていうふうにアメリカの弁護士が言ってきていて、で日本のコーポレートカルチャーも違うしアメリカも違うっていう中でグ グローバルなコンプライアンスのシステムを作るときにそのどこまで考慮するのかとか、どういいコーポレートカルチャーをグローバルで良いとされるグローバルコンプライアンスカルチャーを作るかっていうのは今やっぱり問題になっていて、でその今リスクがグローバルなので当然そのシステム自体をグローバル化していかないといけないんですけど、企業カルチャーっていうのはその国に基本的には根ざしているので、その国ヘッドクォーターがある国の、コーポレートカルチャー、そこで良しとされるものが典型的にはあって、でその中でも全然違うじゃないですか。それをどうグローバルに展開するのが正しいのかっていうのは結構今悩んでるんですよ。でインドネシアの子会社で、例えば同じようなことを全然違うことをやったり、全然カルチャーが違うので、そういう時に僕らがどこまで何をすればいいのかって非常に難しくて、でこの出張の後も私はなんかその次の週にインドネシアに行かなくちゃいけないみたいなんですけど、すごい大変なんですよね。で労働法めちゃめちゃ硬いじゃないですか。インドネシアってすごいんですよ。もう全然クビにできないんですよ。結構な悪いことをしてもですね、裁判所の、オーダーを取らないとクビにできなかったりしてですね、ちょっと厳しすぎるんじゃないかって僕らからすると思うんですけど、ただ結構なんていうんですか、その手続きも硬くてですね、ほとんどもう合意でやっちゃうみたいなんですよ、実際には。だから一定のお金を払って出てってもらうみたいなことをやってるみたいなんですけど、だからその結構な悪いことをしていても、ものすごい守られていて、でそれも国によって全然違うんで、それがベースにあるんで、やっぱカルチャーも全然違う。
そうですよね。雇用システムも国によって全然違うから、だから面白いですよね、比較してね。
そうですね。びっくりしました。
インドネシアでイク・ファリーダさんっていうのはご存知知ら
いや
ないですか？
知らないです。
イク・ファリーダさんっていうのは中央大学でね、修士号を取られた、まあ、日本のペラペラで、
本当ですか。
今年できたインドネシア労働法学科みたいなのの、なんか代表になってるんですよ。
日本にいらっしゃるんですか。
いや、
現地ですか。
現地
後でメールで、
はいはい、いいですよ。
情報いただいてもいいですか。今まさに今やってるんで。
でね、だからもう日本語で議論できるし、だから日本企業みんなそのイクファリーダさんの
本当ですか。
一緒に、相談してると思います。
僕はインドネシアの弁護士資格を持ってる弁護士がシンガポールオフィスにいるので、彼を使ってやってるんですけど、もしよかったら情報いただければ助かります。
さすがです。
インドネシアの方まで。
どうも。ごめんなさい。Deixa esse aqui e repetir. So nobody will be thirsty in this presentation. This is some more additional water.
Thank you.
Thank you. Você prefere que deixe aberto? Se quiser, vou deixar só semi-aberto assim, tá? Toda vez que eu estou na mesa, eu abri uma coisinha dessa. This is very difficult to open. Every time
Sure.
I'm in a session, when I try to do it, go water, stumble on the laptop, so it's crazy. It happens all the time. Look at that. It's not an easy task at all.
Hello, good morning.
Good morning. I'm Shotaramash.
Fernanda.
You remember Maruhashi, Fernanda Takushi?
We've been there.
Two years ago.
2 years ago.
Yes.
So
January
you remember me, so I was introduced by him as a bad lawyer.
Oh, yes. It was very nice that discussion. I
Thank you
hope we
very
can
much.
repeat some of it here.
Yes. It was a very interesting session.
Yeah, it was very remarkable. I think I remember that. It was very good.
Disputing different standpoints and different points of view. So
Yeah, it was very
nice.
And who will speak first?
Him. So I think Judge Gabriela will start.
Hello. Well, everybody hear me? Yeah. Well, good morning. I want to thank you, the organization committee. Here we have Professor Freitas. The opportunity to be here, it's an honor. And we have a great theme. We have to talk about criminal issues and criminal litigation. So we have here today, we start with the Gabriela Hart, with 10 minutes to speak a little bit, and then we'll have the Japanese professors, Shotaro Mahurashi and then Daisuke Fukamizu. Yes? So let's start. Yes. Well, here we have 20 for you and 10 for them. They will speak, okay? So let's start. Let's hear who we came here to hear. Yeah? So,
First of all, I want to thank Professor Antônio Freitas for the invitation and for the opportunity to speak here and encounter some people whom I had the enormous pleasure to meeting in Matsumoto last year. It's an honor and pleasure to be here. I'm so sorry about my English. And thinking about what to talk today, I decided to talk a little bit about the current stage of combating corruption in Brazil. Since I have been the last 5.5 years a privileged and bystander of the path travel to the present moment by the Operation Carwash, the largest criminal investigation on corruption and money laundering that has ever happened in the history of my country, and who knows in the world, considering that the evidence obtained here has already been shared with 52 different countries. Colleagues from outside Brazil may not know, but we are experiencing a moment of great tension, with intense and daily attacks on the work that has been done in combating corruption in Brazil. I remember that combating corruption is a global concern, clearly explained in the preamble to the Merida Convention, or the United Nations Convention Against Corruption, of which our station, Brazil and Japan, are an integral part. In its preamble, the convention states that threats arising from corruption affect the stability and security of societies, undermining the institution and values of democracy, ethical values and justice, and jeopardizing sustainable development and the rule of law. Today, the fight against corruption is also an integral part of the United Nations Global Compact for Sustainable Development, or 2030 Agenda, launched in 2000 by the then Secretary General of United Nations, Kofi Annan. The Global Compact is a call for institutions, public or private, to align their strategies and operations with 10 universal principles in the areas of human rights, labor, environment, and anti-corruption, and take actions that advances societal goals. In a recent held in Curitiba, the president of our Supreme Court defended the participation of the judiciary in discussions on the implementation of Agenda 2030. And since a few years ago, goals have been set to met by the Brazilian judiciary. In recent years, it has been included as one of the priorities for judging processes relating to corruption, crimes, and administrative improbity. Therefore, the fight against corruption is and must also be something that the pursued by judges, because we are part of a global pact that seeks to combat it, and also because it's a goal set by the Brazilian judiciary. We must prioritize investigation and prosecution involving corruption, and seek that punishment for such deviation of conduct is indeed effective. Much more in Brazil than in Japan, considering the instances of such crime in our country and the stage of development of our society. But, of course, in doing so, Judge should not become a hero or villain, should not become the target of hatred or passion, because by enforcing law, we as judges are simply doing our duty. However, precisely at this moment in which the antagonisms in society are clear, we see an inflated Brazilian judicial power. We don't see in other countries such relevant and sensitive demands being resolved by the judiciary as seen lately in Brazil. Legislative omissions and failure in the provision of state service have inflated the power of influence of the judiciary. Judges of the upper courts and even some judges of the first instance in Brazil today are recognized on the streets, receive requests for self and things like that, fact that doesn't find similitude in other democracies. People with diverse backgrounds accompany judgments and celebrate or criticize judicial decisions with the same naturalness and the same passion with which a soccer game is discussed. The extreme public exposition of an activity for which we have always demanded consideration and serenity has brought new challenges so that we can perform our mission well. Given these new challenges, certainly failures have been and will still be committed by all instances because we are human. Criticisms must always be accepted with humility and with the same serenity that are demanded of us in our judgments. Displeasing at least one of the poles of the lawsuit when we do not like everyone, because yes, we just have this ability to displease everyone, always was the day-to-day of the judicature. However, some criticisms currently pass from the limits of the reasonable to simple aggression. Discovering the limits of what is acceptable in a world in which communications are made through virtual networks has also been a challenging, especially for the judiciary. At the moment, the social networks give voice to everyone, and since they are supported by a computer screen or mobile phone, people apparently lose break that life in society poses. It's again a clear idea of Karl Popper about the paradox of tolerance, in which the unlimited tolerance leads, paradoxically, to disappearance of tolerance. We need to be more plural. We need to get used and listen calmly to divergent ideas, while you have to repress unfair aggression. We have to fight false news without falling into trap of prior censorship. And how to do that, how to fix the limits of the reasonable, how to adjust to this new reality without increasing the divisions already so clear and harmful to our society. There's certainly no easy solution, but certainly without our society being prepared to do this analysis, regardless of judicial intervention, we will not achieve such a goal. The preparation of our society for such a reality is necessary due to the improvement of the quality of education and access to critical education. And saying the obvious, because more and more has been necessary to speak and repeat it, we need to study and discuss more history, philosophy, sociology, and mainly ethics. Whether judicial ethics, whether the press or society. Well, after this rambling, I return to discuss on the role of the judge, now especially the criminal judge in the partial application of the law and combating corruption. For me, role goes back to what we learned in the first classes of criminal proceedings. The Brazilian criminal proceedings seeks the real truth. It must be achieved as far as possible to reconstitute the facts narrowing in the accusation so that at the end we can condemn guilty and acquit innocent people. And for that, yes, we need rules that respect the individual rights, because the state, and only the state, must have the power to punish, so as not to become an anarchy. But the state has to use this power while respecting the limits imposed by its people in its constitution. The opposite is abuse of power. The opposite is against democracy, which may not be perfect, but is still the best form of power exercise ever experienced in the history of mankind. But at the same time, the criminal procedure needs to be effective. It needs to be set up within a reasonable time so that criminal law will have the necessary effect of preventing and repressing conducts that are chosen by society as illicit. Otherwise, the state loses credibility. Without effective, victims of the various crimes feel helpless, unprotected, which sometimes make it legitimate to do justice with their own hands. The eternal confrontation between individual rights and processual effectiveness doesn't mean that one would cancel the other. As in every conflict of valid but antagonist interest, we must seek the limits of each one within the criteria of reasonables. Unfortunately, and I have no fear of affirming and being able of punitivist, the Brazilian criminal procedure system, at least from the Federal Constitution of 1988, has pending in much for the observance of the guarantees, even because that was a history necessity of that moment in which we live at the end of a dictatorial era, but neglect the effectiveness of the criminal process. It's fully fair that the right to review every judicial decision, in particular in criminal matters. To review every judicial decision should be set as an individual right. For this reason, the right to the double degree of the jurisdiction as an individual guarantee is provided for in several international agreements dealing with human rights. However, in Brazil, in almost all criminal actions, we have, as a rule, the protocol of person process by 4 instances, and in each of them are foreseen several appeals. I hear a lot of criticisms that say there are too much prisoners in pretrial detention in Brazil. And yes, there is. But it's very clear to me that we have excess of pretrial detention, not because our judges want to arrest too much, but because our criminal prosecution very often takes 15, 20 years to achieve the res judicata. We will wait 15, 20 years to incarcerate a violent thief, to incarcerate a qualified homicide, a powerful corrupt. If we had a more agile process, but still guaranteed individual rights, wouldn't it lower our prisoner rates before trial? Reaching the limit legal time barred for criminal proceeding is an anomaly that should be the exception. But in Brazil, this anomaly, in addition to being very usual, has its consequence aggraved by the fact that its recognition also lets all the side effects of criminal conviction, including the failure of assets earned with the benefits of the crime. Thus, I defend and will defend whenever it is constitutional, legitimate, and necessary the execution of the penalty after the judgment of the process in second instance, as decided our Supreme Court in 2016. A setback in this point will again contribute to the loss of credibility of the Brazilian state in fight against crime. It's widely spoken that our criminal process is excessively punitivist because Brazil has one of the highest incarceration rates in the world. Brazil actually has more than 700,000 prisoners today. This number places the country in 26th place in the world if considered the number per capita, and in 30th position in the world in numbers, absolute numbers. However, I ask, are these data disproportionate if we analyze the degree of violence and criminality we have in our society? In a work ranking of homicides, Brazil occupied the first place on the list. The feeling of insecurity experienced by Brazilian population is something that does not compare with almost any country in the world. And what about the corruption rates? So, gentlemen, the simple analysis of the index of Brazilian incarceration, unrelated from the analysis of the high crime rates, and it's an empty analysis. It is also that crime will not only diminish with the punishment of criminals, much less with incarceration for any and all crimes committed. Alternative sentences to prison are often better and more didactic if we analyze criteria for prevention and repression of criminality than incarceration. But it's also true that such alternative measures need to be better measured and monitored. In the fulfillment of penalties, the growth of criminal organization in Brazilian prisons show that the Brazilian state also neglect the necessary resocializing bias that the prison has to guarantee its convict. Anyway, we have a system that later punish, and when punished, did not know how to do it. We need the certainty and the effectiveness of the punishment, and that such punishment, be it prison or alternative measures, serves so that the convict pays to the society and the victim for the mistake he has made, and that he doesn't not want to do other mistakes. At the same time, of course, it's necessary for the state to guarantee the basic needs of the population, with acts for a better income distribution, which provides an adequate and economic education, because in these indices we are also far below what's understood as reasonable on a global scale. Well, this index demonstrates that what has been done so far has not been adequate. Operation Car Wash, which has been so heavily attacked, is rather a point off the curve. It's rather a criminal investigation model. Some of the results of these cases already judged have no precedent in Brazil. But it is certainly that it is still an ongoing investigation and that it fits criticism and at very points of its driving. But we can't stop. We can't not let them throw away so much effort and all the results already obtained in the recovery of assets, in the sharing of information with several other jurisdictions, in the breaking of many paradigms. Obviously, when you fight power for force, we should expect them to use all means at their disposal to keep the power conquered. This new reaction is sharp at the current moment. The union of several forces against a work that has been shown to be effective is clear. I understand that history is not written in straight lines, but rather inspires, in which advances and setbacks alternately. I see that here, now, we are going through a moment of setbacks in several respects, and perhaps not only in Brazil. But in Brazil, I include the visible setback in fighting corruption. Anyway, I hope and trust that this moment of crisis serves as a real window of opportunity for us to react, perfect our institutes, and following examples for other countries that have overcome similar crises, we can have a country stronger and more reliable with less corruption. Thank you for your attention. So sorry for my English.
Thank you, just Gabriela. Now we are going to hear Professor Shotaro Maruhashi.
Bom dia. Obrigado. I'm Shotaro Maruhashi, Shinshu University. I'd like to thank you for giving me the chance to speak today. Last year, I told about the Agreement Act, so-called Japanese pre-bargain, before coming in force. Coming into force. Do you remember Japanese call him 悪い弁護士? 悪い弁護士 mean a bad lawyer. Today, I would like to talk about that after coming into force, compared to English deferred prosecutor agreement and Brazilian cooperation agreement. Introduction. Japanese government amended criminal prosecution in 2018 about negotiation and agreement for cooperation, so-called Japanese pre-bargain. The amendment came into force from June 2018. I will explain the Amendment Act, particularly about the outline of the Japanese pre-bargain. After my speech, lawyer Wari Bengoshi Daisuke will talk about the first case and practical issue. About background, the main purpose of the act is to address organized crime, including Yakuza crime. At least academic scholars mainly thought about anti-Yakuza. Yakuza means organized crime group in Japan. Yakuza has two features. First is fictitious blood relationships. Second is unquestioning obedience for the boss. In other words, a strict hierarchy. Do you know the film Godfather? It's like Godfather. The boss is Michael Corleone. Do you know? For example, imagine the case that boss X ordered Y to shoot A. As a result, Y shot A and A died. Please raise the hand if you think the most responsible person is the X or Y. As a general, Japanese think the most responsible person is X. But it is said that the way of thinking is different from that of Germany. Germans think that it is the most important, most responsible person is Y, who shot A. So Japanese think that it is the most important to punish the boss because the most responsible person is the boss. So Japanese academic scholar thought that the main expected case is to agreement with the subordinate Y in order to punish the boss in the organization. About procedure. Here, I will explain the Japanese procedure compared to English DPA and Brazil cooperation agreement. The negotiation is carried out between a prosecutor and suspect or defendant and counsel. A suspect or defendant may be both individual and corporation. It is very different from English DPA and Brazil CA. So, okay. I would like omit the other procedure. The offenses specified in the act, the main offenses are organized crime, as same as Brazil. It is the offenses include corruption, Japan in Japan too. Okay, I would like omit the other. The other party of the agreement was expected as individual at the beginning. The agreement with a corporation is not enough to be considered in the economic crime in the course of lawmaking. Academic scholar think so. Agreement about agreement. Subject prosecutors can agree with suspect on the P do A. Sorry. If SD do B about the other case, which means that SD can agree to B for in own case. The not to charge prosecutor do not charge charge with a reduced count 3 suggest a reduced sentence or charge with summary proceeding. SD state truth in trial or investigation or cooperate to adduce evidence. There is no disgorgement in Japan, different, unlike DPA or Brazilian system. I would like to omit court approval. I would like to conclude my presentation. English and Brazilian system are the total different. The expected party of the agreement in Brazilian CA is individual, whereas those in English DPA is a corporation. Japanese plea bargain is in middle between Brazilian and English DPA. Interestingly, at the beginning, the main expected case is to agree with a subordinate in order to punish the boss in the organization in Japan, like Brazil. But now, practitioners think that Japanese plea bargain is the most suitable for economic crime, like England. But some problems remain in Japanese plea bargain in order to make an agreement with cooperation in economic crime. Because the other party of the agreement was expected as an individual, and the agreement with the corporation was not enough to be considered in economic crime in the course of lawmaking. At least academic scholars think so. That is from me. Next speaker is Mr. Daisuke. Thank you for listening. Obrigado.
Thank you, Professor. You were just close at your timing, so we're 10 minutes really sharp. So now we'll hear Professor Dayakuzi. Yes, you can speak.
Yeah. Thank you very much, Gabriela and Professor Maruhashi. So I'm Daisuke Fukamizu, partner of Nagashima Ono Tsunematsu, and I'm also an associate research professor of Shinshu University. As a practitioner, I'm focusing on crisis management, compliance, and government investigation defense matters, especially those cases which have global aspect. I'm honored to be here and to have good opportunities to speak at this seminar in front of you. In my part, as Mr. Maruhashi explained, I will discuss Japanese first pre-bargain case, which was officially made public in July last year, and its reaction from Japanese society. And then I will discuss several potential issues arising from the first case and possible solutions to effectively address corporate crimes. Okay. So I will start my presentation by introducing the first case. As mentioned, the first case was made public in July last year, which was just a month after the new regime launched in June 2018. In this case, Mitsubishi Hitachi Power System, which is so-called MHPS, entered into the pre-bargain with a prosecutor for an investigation into alleged bribery to foreign officials in Thailand. With respect to the underlying facts, the case was initially discovered in 2015. In February the same year, an employee of MHPS paid approximately 20 million Thai bahts to a subcontractor. It was alleged that the fund would then be passed on to the Thai government officials in exchange for such officials to grant the permission to use a port during the construction of a power plant in Thailand. Then MHPS conducted an internal investigation with outside counsel and submitted to the written report to the public prosecutor's office in June 2015. After the voluntary disclosure to the investigative authority, MHPS had continued to cooperate with the criminal investigation. And the public prosecutor's office then proposed to enter into the pre-bargain just after the launch of new regime. Then MHPS entered into an agreement with the prosecutors, and MHPS successfully avoided its prosecution against the company. And as a result of MHPS's cooperation with the criminal investigation, two former executives and one manager of the MHPS were prosecuted. One of the former executives and the manager have already been convicted, but one of the former executives had pled not guilty, claiming that he did not allow employees to offer bribes. With respect to the last case, the court decision was just made last week, on last Friday, September 13, and it was said that in the news that he was also convicted. Then let's move on to the reception and the reaction of the first case by Japanese media and society. As you may expect, many of Japanese media outlets have made comments critical of the MHPS case, since they claim that MHPS avoided its prosecution by sacrificing employees. For example, the title of the Nikkei newspaper regarding this case is questionable first case of plea bargain, stating that, as described in this slide, it seems that this is not a case of tail shedding, as those who were prosecuted were senior managers. However, the result of the bargain was that the company avoided prosecution while only individuals bore criminal responsibility. In addition, the business magazine called Nikkei Business also published an article stating that a company usually understands the crime committed by an employee and thus has not taken severe actions against its employees. That is a traditional attitude of Japanese companies. And Japanese society is also broad-minded about the crime committed for a company. And in my idea, it seems that these are expected basic reaction of Japanese society. As described in the article in this slide, traditionally, Japanese society is broad-minded about the crime committed for a company. It looks like these reactions stem from Japanese traditional idea of family, health, or historically han, which gives significant importance of community, not individual. Briefly speaking, under the traditional Japanese society, while individual is not so important and independent, continuity of the community and its owner or reputation are much more important. Under that regime, it is not considered. It is also considered that community itself should protect and take care of the members within the community, and also the community should take its responsibility for the problems occurred within the community. This traditional and basic attitude toward community may affect the attitude toward the companies in the modern world, and then created such reaction against the first case of plea bargain. On the other hand, reactions from Japanese practitioners are mixed. Whilst some traditional criminal defense lawyers focusing on individual crime cases showed similar reactions to the public, some practitioners, those who deal with corporate crimes, including me, pointed out that the first case may be the good message from the investigative authority that they will intensify crackdown on corporate crimes through the new regime. There are several aspects which I should note in the first case. The first, I believe that this is the most important point in the first case. The company, not an individual, was a party of plea bargain. This could be a good message that encourage companies to make a voluntary disclosure to the investigative authority and cooperate with an investigation. Second, by dealing with foreign bribery, the investigative authority in Japan responded to the criticism that Japanese authorities have been long reluctant to investigate overseas bribery and corruption issues. Third, by dealing with the case where the company identified the wrongdoing through internal confidential reporting system, which is the whistleblowing system. This could be also a good message that preparing effective corporate compliance program could be benefit for the company, because they can get an opportunity to cooperate with their investigative authority and get immunity. As such, some practitioners have made comments from corporate crime perspective and generally received the first case positively, at least to some extent. Having said that, we can also find some problems to be addressed from the first case. While the Japanese pre-bargain system can potentially be a good, effective tool to address corporate crimes, there are several issues to be overcome in order for the system to work effectively to address corporate crimes. In order to design a good incentive structure to address corporate crimes, we need to make negotiation process more transparent and to reduce uncertainty. If there's an uncertainty, it is hard for me, like defense lawyer, to convince the company to cooperate with their investigation. So, yeah, firstly, while the head of public prosecutor office made a comment in this slide on the use of the new regime, in, yeah, I believe that it looks like it is a little bit too abstract and still not clear that to what extent the investigative authority wants to address corporate crimes and on what circumstances they are willing to use new regime. In other words, it is not clear as to what kind of policy they have and will take in order to address corporate crimes, including corruption issues. Secondly, as described in the slide, there are no guidelines and guidance with which publicly available or regarding factors to be considered in a negotiation regarding the pre-bargain. That, in fact, cause uncertainty with respect to the negotiation, and it's possible result under the current regime. It is not easy for defense counsels like me to discuss the case without established framework and structure. In order to address these issues, I can propose several possible approach to increase the transparency of enforcement policy. Given the limited resource in government investigative authority and limited access of relevant data and documents which are potentially located globally, the difficulty to understand the details of complicated business which the company are operating, it is very important to design and create clear and strong incentive to encourage companies to conduct an internal investigation and make self-reporting regarding the wrongdoing they're identified. And at the same time, it is important to strengthen the enforcement activities. To achieve this, firstly, we need to increase the transparency of government enforcement policy in order for the new system to work effectively to provide companies an effective incentive to improve their corporate pricing function. The benefit they can obtain through these efforts should be as clear as possible. Secondly, we need to establish a good negotiation structure for potential parties of agreements to discuss the case. In this regard, I believe that factors to be considered described in the DOJ, US DOJ Justice Manual can be a good example. In addition, like UK and Brazil, there are a lot of guidance we can learn from abroad. And based on these examples in other jurisdictions, we can establish our own framework to discuss the case for pre-bargain. As discussed in the previous part of my presentations, Japanese pre-bargain system is originally designed to enter into an agreement with individuals, not companies. In order to address corporate crimes, we believe that we need to discuss further for the new regime. For example, current regime does not allow a prosecutor to require within the framework of negotiation and agreement the company to conduct the reform of corporate governance and compliance program. Since, as you know, the governance and compliance improvement is one of the important factors. It is reasonable to give prosecutors an authority to require governance and compliance reform in an agreement. While it is not easy for a prosecutor to evaluate a corporate compliance program in a specific case, but we can learn from other jurisdictions' effort, such as US DOJ's new guidance, which was updated in April this year, regarding how to evaluate the corporate compliance programs. Unlike DPAs in the UK or Clean Company Act in Brazil, there's no clause and authority regarding disgorgement under Japanese agreement regime. In order to use a new regime to address corporate crimes, including corruption, it is reasonable to establish a new clause regarding disgorgement to achieve public interest and mitigate the risk of moral hazard. Also, we need to discuss whether the government should provide an affirmative defense for effective compliance program. Traditionally, academics like Professor Maruhashi have considered that there is a room for a company to argue effective compliance program as an affirmative defense in a corporate crime cases as a matter of interpretation of criminal law. However, it is not common in other jurisdictions to provide such an affirmative defense. We need to develop this discussion in the future. As discussed, we have found several issues discussing points regarding Japanese pre-bargain system. Based on the discussion we had in the presentation, we plan to make further discussions to prepare for the opportunity to review the current regime planned in the near future in the several years. Thank you very much for the attention.
Thank you, Professor. Now, if we want to honor our time schedule, we have 12 minutes to our discussions. So yes, we have a first question. Professor Freitas, yes?
What do you think about the judge instructions? Juiz de
Judge?
instrução, separately from the judge, which is in charge of definitely decide.
The separation of the roles. O juiz de instrução ser diferente do juiz que vai julgar.
Right now in my court, we are working like that. I just analyze the case before the evidence, before the accusation. And Bonar, my colleague, start to analyze after the accusation. So we are working like that right now. So I think 1 year after, right now, we can speak more comfortable about the experience. I think there some things good, some things not good, but I think the defenders feels more comfortable. Defendants.
As we could realize in the presentation, the evaluations are different depending on the point, the standpoint,
Right.
of the practitioners different from the
Right.
from the prosecution. So it was in the that if we separate the judge who's in charge of the instruction and the judge who decides, can give more credibility and to the instruction itself. I have another question for you about the bargaining, the negotiation is confidential, and whether if it's confidential or not, do you have any institution in charge of the control of the negotiation itself?
Okay, that's a good question. The negotiation itself is confidential, but the agreement entered into between prosecutor and defendants or could be fired. So they must prosecutors have to file that agreement as an evidence when they file a criminal litigation. So it is public. It could be public. So what kind of agreement they enter into? And the second question, so there's no such institutions to monitor so the negotiation and the result of their agreement. But there's, while there's no such institution, judges can evaluate the evidence, so which is an agreement they enter into. And if it is not fair, or so their, how can I say, the statement of their cooperator is not credible, judge can assess the evidence, and it could be possible to decline or evaluate that it is not so credible. So I think through that process, there's some monitoring function. We can say that there's some monitoring function the judges can play in that process.
Anyone wants to make a question? I have one that I think it's a common matter about the press, the journalists, and the reaction. This is something that bothers us from our perspective because they have a different view about that. There is an old phrase that says the role of journalists is to bother the people who are calm and to calm people who are disturbed. So they have this kind of intention of making things feel different. So I'd like to hear Judge Gabriela and professors about uh, how do you think that the media press role can help or not about transparency? That's a problem. We have to have more information, but sometimes they have this kind of intention to make things more hot. Huh? Yeah, yeah. I'd like to hear you about that because it's something that gives us mixed feelings. We think it's good, but sometimes they overreact in some points. So if anyone wants to start, I guess Professor, yeah?
Me?
Or him, I don't know. Who's ready?
Okay, so yeah, I will start the discussion. So as I described in my presentation, the reaction against the first pre-bargain case is from the media is critical, and they're conservative and they criticized their first case because the company avoided its prosecution. Yeah, it's expected, and it's generally the basic idea. But since they're, how can I say, traditionally, so Japanese think that achieving criminal justice is really important, and they're generally conservative to bargaining the case, criminal case. And in addition, so if the company, yeah, basically the company should be responsible for the crime which is committed by for the company. So these two reasons, the media had the position to criticize that first case. But as a practitioner and a professor, I think it will take some time to explain why the first case could be effective to address corporate crimes, and the reason to it is good to encourage company itself to prepare for the good compliance system and to conduct an internal investigation to collect good evidence and to submit or to share the evidence with their investigative authority, and to design a good incentive structure as a whole criminal system is really important. But it is not easy to understand. So, and after the media reactions, I think it is our role, practitioners and professors, to justify or to give a different idea or perspectives to the public to discuss their effectiveness of the use of free bargain.
But it's not an easy thing to explain from for who doesn't work in this area. And I think like in Japan, here in Brazil, in Brasil-Japão, the law didn't preview the how to make the agreement. So it's very difficult to explain how they achieved uh, this agreement. So I don't know. I don't to talk about the media uh, uh, in our work is very difficult to say like right now because right now is a problem. I think the we need to be transparency, but some things are I can't speak in English. Eu falo com vocês, talvez você traduz para mim. Porque algumas circunstâncias são explicadas de forma muito simplificada e acaba dando interpretações errôneas.
Yeah, sometimes there are some simple explanations that don't translate all the complexity, and the journalists don't say it properly.
Yeah.
Yeah, it's complicated.
It's complicated to work with media exposition.
Yeah.
日本語でもいいですか？
Here we don't have a play bargain in criminal justice with companies, but we have civil play bargain, administrative play bargain, and company are paying
Fines, multas.
fines. And in Japan, don't you have something like that in civil or administrative?
Yeah, so in some cases, like including corruption, so there's a criminal offense for the company, and the fine is really problematic. The Japanese fine is relatively low, than relatively low, much lower than other jurisdictions. Like the corruption issue, the maximum fine is 10 billion, 1 billion yen, which is 10 $1 million maximum.
Maximum.
Yeah. The average is much less than
Yes.
that. And if there, yeah, I think the fine or penalty should be threat for the company not to commit the crime. So in that regard, so as you know, so there, I believe that the maximum penalty should be increased in the future to address corporate crimes.
So, what's that? Well, we we have a deadline here. It's our time to finalize. So, I want to thank you, professors, Judge Gabriela, and everyone for this session. And let's go to the end of our session. Professor Freitas wants to say something? Okay. So, thank you very much.
ちょうど10年ぐらい前ですね。2008年からですね。
あそこでブラジルと常松先生もリタイアされたんだけど、
そうですね。三笘さんと
野
か。
村証券の弁護士としても何回かブラジル
あ、そうですか。
1970年代長嶋先生は来られなかったけど、お嬢さんがポルトガル語を勉強したり。
あ、そうなんですか。私よりもずっと彼らに詳しいですね。
大竹。
大竹、はいはいはい。
彼のおじいさんはブラジル大変関係のある人。非常に面白い、数奇な一生を送られた方なんですね。
そうです。大竹さんのおじいさんですね。
私はあそこで一番親しいのは動画打ち。
はいはいはい。国際法の。
よろしく。
ありがとうございます。
Congratulations. Very, very nice. We're thinking about using this material
I don't have
for
it.
future exhibition.
But I write to you. So sorry. I know Japanese.
Oh, article.
Article
Yeah,
depends on
I'm happy to cooperate with
I
that.
forgot to bring
We're going to be in touch. Thank you.
よろしくお願いします。しかし、信州大学で教えに行っても儲けにはなりませんね。
彼が私の先輩なんで。よ
くわかりますよ。
ただこういうのも。
長島元の先生を信州まで引っ張り出すのはなかなか難しい。
けどこういう活動自体は大事だと思ってます。
結局私は昔からね、ブラジルでは憲法でプロがですね、自分の専門科目を大学で教えていることは昔から憲法で保障されてました。兼職ではないということですね。ですから判事も検察官も、弁護士はみんな教えて、もう一つは大学のフルタイムプロフェッサーでは生活が成り立たないんですね。例えば私は3つのレジュメがあってですね、フルタイムとハーフタイムと、私も最初から分かったから12時間という、4分の1タイムで、私のこのサンポロ大学の給料はですね、日本のお金にして 5万円ね、手取り4万円ね。
ボランティアですね。
いやもうだから最初からもうこの当てにしてフルタイムのプロフェッショナルだったらどうだってせいぜい30万とか40万で、それはそれでやってる人もいるわけだからそういうこと言いませんけど、あれですね、そうしたら例えば本書いたり意見書書いたりね、それなりの副収入はあると思うんですけど、大学の給料だけでやっていくと難しいです。みんな幹事とか賢者はですけど、教えても別にそんなにお金になるわけじゃないからね。弁護士、それから医者、エンジニアなんてのはそれぞれ別に病院で働いたり、診療所持ってたりしてるね、やってるんで、なんとかって感じですね。いや、どうも。
少しでも貢献できればと思います。またよろしくお願いします。
私が申し上げた大竹さんとか動画打ち君に会ったらよろしくお願いします。
ありがとうございます。伝えておきます。
So this is the first time to come to Brazil. So I'm really looking forward to go to US.
Next
How
time.
long will you stay there? 5 days there? In Brazil or Argentina?
In Brazil.
Brazil.
Next time we will go to the pretty.
Okay. It's not fair from Basura. But I really like it. I have to go. I was thinking about to go to Japan to see the Olympic Games, but it's too expensive to do it.
He can support.
Financially.
Financially.
メールでドラフトを送ってくれるかな。そうそうそう。メール、E メール。一応僕もやってるから。そうだね。 todo mundo meio que dando uma pressa. A outra vez eu falava muito alto.
これ本当はガブリエラさんに山ほど質問があるんですけど、
ねもう帰っちゃう。
けどメールで回答するの難しいですよね、裁判官が。
そうだね。しかもなんか
今ちょっと聞くべきじゃないですよね。
顔種がね。あ、これも直してくれたの。USB とか抜いてくれた。
僕は絶対に入れてないですけど、入ってたんですよ。彼に聞いてUSB って刺さってました？それとも最初からパソコンに入ってました？それをコントロールするんです。大丈夫です。
May I have your attention, please? First, before moving on to our final closing session, I would like to inform you that we're going to make a call for papers anytime soon, and we'll inform you of the specifications, the parameters for the papers. Next, I would like to introduce you Professor Masato Ninomiya from São Paulo University. Professor Masato is one of the precursors of Brazil-Japan comparative law studies, and also the person responsible for the partnership between Shinshu and São Paulo University. So Professor Masato, would you mind saying a few words first, please?
Well, good morning, my friends. And I was designated to make the final remarks. But first of all, I would like to say why I was so interested in helping the agreement with São Paulo University and the Shinshu University. The reason is that I was born in Nagano Prefecture, not exactly in Matsumoto City, which is a huge city, but a small city called Ueda. Well, another culture, another civilization, but anyway, I am from Nagano Prefecture, and since I have been helping the celebration of agreements with other Japanese universities and the University of São Paulo, why not to help the university of my home country? This is why I was in charge of helping people of Shinshu University celebrate this agreement. And this is a second seminar. The first one was in January 2018, and I received an homage in Shinshu because of this help I made. Just Daniel Machado called me, what did you call me? And it's another elegant way to call the old man. Of course, Professor Kazuo Watanabe is much more veteran than myself. But we are both veterans in this relationship with Brazil and Japan. So I would like to salute all members, mainly the Japanese people who came to participate in this seminar, but all participants of the second Brazil-Japan Litigation Society seminar for the richness of the contents, not only the labor matters, but also about all matters discussed here, cultural diversity and global challenges, ADR, family law, environmental law, criminal litigation, and so on. Thank you for the organizers of this seminar for inviting me to make these final remarks. I was very impressed for this high level of each presentations, and all presentators, both Brazilians and Japanese guests, and mainly for the even for the young researchers who participated in the roundtable presentations. Unfortunately, I couldn't participate in all of them, but I think it is the first time in this kind of seminar that young researchers made such a kind of presentations. And even now, this final section was divided in the Professor Judge Bruno and Fernandez, two different sessions simultaneously conducted in two different rooms. This was not the experience we made before. Mainly because of the language problem we had before. I think it's the first time that all works were conducted in English. In the last 30 years that me and Professor Kazuo organized such a kind of seminars, I have collaborated as interpreter of these seminars because not everybody was so competent in English language. So we are looking at a new era, new generations, new young people working in this bilateral relationship between Brazil and Japan. So differently of other times, I think these young people, Brazilians, and well, we have two kind of Brazilians here. We have Brazilians of genuine Brazilians and descendant or Brazilians with Japanese ascendancy, who has more facility to understand Japanese. But we have a phenomenon as Daniel Machado here, who is non-Japanese, but he can speak better and write Japanese better than many Niseis or Sanseis who educated him in Brazil. So I want to congratulate Daniel Machado and other people, other non-Japanese Brazilians who made us think huge effort to learn Japanese language. And he studied law in the University of Tokyo. He went to the graduate course in University of Tokyo, wrote a master thesis in Japanese language. He was awarded by this master thesis, and now he's in the doctoral course. And probably he will be the first non-Japanese Brazilian to become a Doctor of Law by Tokyo University. The first one was myself, but anyway, I had the facility to understand Japanese language since I was born. Well, what I want to say is that I think Professor Kazuo and me, we are very happy to see these young generations growing, and probably they will work very hard in the relationship with Brazil and Japan. We have a number of Japanese and Japanese descendant Brazilian who became a lawyer in this country. Today, our dean told professors from Japan that University of São Paulo was founded in 1934. So we have 85 years of history, but the Faculty of Law was founded in 1827, the same year of Akamon Gate of Tokyo University. In 1934, I have to call your attention that it has passed 26 years after the arrival of first immigrant here in Brazil. And in the year of foundation of the São Paulo University, we see already one or two names of Japanese descendancy here in the Faculty of Law. We have seat in the Faculty of Medicine, Engineering, Agronomy, and the Faculty of Science, Letters, and Philosophy. But the main point is that here we have already one Japanese and one Nisei already studying law in 1934. So today we have, after 85 years of University of São Paulo, we have a huge number of lawyers. The first judge was Professor Kazuo. We have another judge as Bruno, and we have prosecutors and a huge number of attorneys at law, and also many university professors who has Japanese name. So this is a situation in Brazil, and many of them can understand the Japanese language. And what is happening in Japan? We have in Brazil, I mean in Japan, some people such as Daniel and other members of study group of Japan-Brazil legal system. And we have a huge number of so-called Dekasegi people. We counted 320,000 in 2007, and it has declined because of the financial shock 2008. But today we have again about 200,000 people. Among them, I want to mention the name of Renan Teruya, a boy who arrived in Japan with 8 years old and studied every time in Japanese public school, graduated in law by Nagoya University, and went to law school in Nagoya University, and he passed in probably the most difficult examination to enter the Legal Training Institute maintained by Supreme Court. He was the first Brazilian to accomplish such a big deal. And now he finished the legal training and became a lawyer. He is in Nagoya, practicing law, and his idea was to help Brazilians who were living in Japan. So, what I want to say is that, yes, I and Professor Kazuo, we have veterans. We are veterans, we are old soldiers, but we have new generation people, very brilliant. We have a number of, probably we have 200 to 300 Brazilians studying in Japanese universities. We have also probably the same number of Brazilians who passed some years in Japan and now they came back to Brazil and they are studying in Brazilian universities. We created a small scholarship to help them, and we had 2 law students already. They are from Sorocaba and they are from Campinas. And yes, they finished their law studies, and one is working as clerk in the Sorocaba First Instance Tribunal, and in Campinas he became an attorney. So my task was to comment different presentations, but I think all presentations were very brilliant, effective, and very inspiration. Brought very many inspiration for us, mainly our guests from Japan and our Brazilian collaborators too. So I think I have my obligation now is just to say words of greetings and thank you for everybody who contributed to the success of this seminar. And another thank you for the Japanese delegation. And I know that they are going to, some to Iguazu, other to Rio de Janeiro. And I wish bon voyage back to Japan. Thank you very much.